This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Hosted by Katie Milkman, an award-winning behavioral scientist and author of the best-selling book, How to Change, Choiceology is a show about the psychology and economics behind our decisions. Hear true stories from Nobel laureates, authors, athletes, and more about why we do the things we do. Listen to Choiceology at schwab.com/podcast or wherever you listen.
This episode is brought to you by Shopify. Do you have a point of sale system you can trust, or is it a real POS? You need Shopify for retail. From accepting payments to managing inventory, Shopify POS has everything you need to sell in person. Go to shopify.com/system, all lowercase, to take your retail business to the next level today. That's shopify.com/system.
Over the past 4 decades, a revolution in robes has changed the way America does constitutional law, and therefore how all Americans live their lives. Remember how mad you were after Dobbs, after Bruen, after the Supreme Court swept away affirmative action and the separation of church and state? Every one of those developments is traceable to the near monopoly of an old-sounding but actually relatively new brand of constitutional interpretation. The new way some justices divine the meaning of the law? Originalism. The cases vary, but at their heart is the same lie, that all constitutional law is frozen in the views of white men from the founding, and that judges can reliably decipher exactly what those men thought.
At the time of its creation, originalism promised an approach that would encourage judicial restraint. The theory instead delivered a Supreme Court unbound by precedent, doctrine, or even the text and history it claims to worship, wiping away hundreds of years of common law in its wake. What's more, originalism is deadly. There's nothing theoretical about the lives upended or snuffed out as a result of decisions delivered under the banner of originalism, like the gun cases Heller and Bruen impairing the government's ability to combat out-of-control gun violence, and the overturning of Roe v. Wade, triggering abortion bans that deny women access to life-saving care.
Welcome to How Originalism Ate the Law, a special series here on Amicus, complemented by a package of expert pieces at slate.com/originalism. We're going to explore the how, the why, and the what of originalism. How originalism became an article of faith for the right, why the left capitulated, and what the hell are we going to do about it? I'm Dahlia Lithwick. I cover the courts and the law and democracy for Slate.
And I'm Mark Joseph Stern, senior writer at Slate, covering courts and the law.
Let's go back to the beginning. We are firing up the Amicus time machine to uncover originalism's origin story. And we're going all the way back to almost prehistoric times. We're going back to...
Hearing will come to order, please. I welcome everyone here this morning. Judge Bork, his distinguished panel of introducers, my colleagues, and the public.
The 1980s.
The 1980s? My parents have pants older than that.
Joseph Biden definitely has pants older than that. The voice you just heard was President Biden back when he was chair of the Senate Judiciary Committee on September 15th, 1987, the first day of confirmation hearings for Ronald Reagan's ill-fated Supreme Court nominee, Robert Bork. Here's Bork himself talking about his own method of constitutional interpretation.
How should a judge go about finding the law? The only legitimate way, in my opinion, is by attempting to discern what those who made the law intended.
So the story we hear and the story we tell about the Bork hearings is that Democrats rejected him because the balance of the court was at risk, right? Lewis Powell was retiring. He was a swing vote. Bork would swing the court to the right. Plus, Bork had participated in the Saturday Night Massacre during Watergate. And then the story that Republicans walk away with after Bork is voted down is that Democrats suddenly went rabid and partisan and attacked his character and smeared a good man and started us down this path to forever conflicts over confirmations that effectively broke the Supreme Court, possibly for the rest of all time. But Dahlia, you're saying that the Bork story is also part of the originalism origin story?
You know, it really was. Bork's confirmation hearings were also, in a sense, the kind of trial balloon of how do people feel about originalism? And it didn't go well. Robert Bork was an unalloyed, unapologetic, unrepentant originalist. He was just a bad pitchman. It was not a very good performance in the kind of huge arena of national discourse about what courts do and what law is and how you interpret the Constitution. This idea that was kind of old sounding, but it was really new and radical, was mostly met, I think, by the American public with kind of horror and disbelief and a desperate wish to run back to the returns counter and give it away. And probably the most famous or infamous distillation of what originalism might do to America comes from the memorable speech made by Senator Ted Kennedy during that confirmation process that becomes known as the, quote, Bork's America speech.
Robert Bork's America is a land in which women would be forced into back alley abortions, blacks would sit at segregated lunch counters, rogue police could break down citizens' doors in midnight raids, and school children could not be taught about evolution. Writers and artists would be censured at the whim of government. And the doors of the federal courts would be shut on the fingers of millions of citizens for whom the judiciary is and is often the only protector of the individual rights that are the heart of our democracy. America is a better and freer nation than Robert Bork thinks. Yet in the current delicate balance of the Supreme Court, his rigid ideology will tip the scales of justice against the kind of country America is and ought to be.
It's eerie how familiar that Back to the Future stuff feels now, post-Dobbs, post-Bruen. But this was the before times. And when Bork laid out the originalist roadmap, a map to take us back to when the Constitution was written, when the things Senator Kennedy laid out would be utterly consistent with the law of the land, that roadmap was so extreme, it was rejected. And I think in a way we kind of glibly dismissed it. But that was really just the beginning because, think about it, Bork was rejected, at least in part, for the perceived extremism of his originalism, but he'd be confirmed in a heartbeat today.
He'd be a squish today. I mean, he would be like centrist in his belief that there are actually issues that the judiciary should not resolve for once and forever, that there are matters the court should stay out of. I mean, Bork, in my view, was a terrible person and a rotten judge, but he really did view originalism as a restraining mechanism for the courts. And that simple belief in judicial restraint would shift him way toward the center of today's court, which I think is really shocking and disturbing. And Dahlia, I just think it's so interesting that he becomes the archetype for the victimology and like the ahistorical nature of originalism. He becomes so much larger than what he was before Ted Kennedy gave that speech. And he's ultimately like kind of the reason, or at least one of the reasons, why years later, fast forwarding to 2016, Republicans wouldn't let Obama fill Scalia's seats.
So two interesting things I would say about what you just noted, Mark. One is Bork made the mistake of telling us what it was, of explaining it, of sort of saying, take into its logical conclusion, here's all the stuff originalism would do. And maybe the takeaway from Bork's flame out, having tried to do that, is that then we had to start to speak in code. I guess the other thing that we should just sit with for a second is that while there were versions of originalism floating around, this is a notion that was invented in the 1970s and 80s. And the country was not ready for it in the 1970s and 80s.
Ultimately, the most tragic part of it is that Robert Bork voted down, brutally rejected by the American people and their representatives. He gets the last laugh because now we live under an originalist court, and they are claiming that this methodology will reign supreme. But Robert Bork didn't invent originalism, right?
I mean, there had been scattered writings and mentions, but no. In fact, Paul Brest is often credited with coining the term originalism in 1980 in his book, The Misconceived Quest for the Original Understanding. Brest was trying to name this new appeal to the founding as the font of all knowledge and reason in constitutional law. Brest named it. He didn't invent it. Bork tried and failed to sell it, but he didn't invent it. The actual birth of originalism involves a confluence of interests and institutions, and I know just the man to ask about that.
So, Dahlia.
Hi.
What can I do for you today?
Well, start by telling us your name and the name of your book.
I am Jack Balkin. I am the Knight Professor of Constitutional Law and the First Amendment at Yale Law School. And I have just published a book called Memory and Authority, The Uses of History in Constitutional Interpretation, which is available at fine bookstores near you.
And Jack, you won't remember this, but the first email I ever got from you was...
I was trying to sell you aluminum siding, perhaps?
No, it was probably 20 years ago, and I was like scratching my head, like, what is this originalism of which they speak? I feel very hinky about this. And I wrote some stuff and you wrote to me. So we actually met and bonded over this project. But I would love for you to just walk us back. I always trace it to, Reagan and Ed Meese and Justice Scalia and Bork.
I'll give you a part of history, but interrupt me because, I'm a law professor. I'll keep going forever.
Bring it on.
It's really the events of the period between 75 and 85 that are really the crucible that creates originalism. Ronald Reagan's elected, and his second attorney general is Ed Meese. And Ed Meese decides that it would be very important for the conservative movement to get behind a particular way of interpreting the Constitution that would be likely to produce conservative results. And he settles on what he calls the jurisprudence of original intention. And he tasks people in the administration and also in the Justice Department to start working on studies of what would constitute the original purpose or original meaning. And they're not too clear about which version of originalism they're using. They just call it originalism. And it's not really very good history. It's just a bunch of claims making. So Meese thought that the Bill of Rights didn't apply to the states, and he thought that that was the original intention. He was wrong about that. And they had to do a whole bunch of different, they did a bunch of position papers and all that. And so over time, what happens is really interesting institutionally. First of all, you start getting a group of young, smart lawyers who are conservatives who start to ally with originalism. So in the Reagan administration, the Bush administration, there's a young man by the name of John Roberts. I don't know if you ever heard of him. I wonder what became of him. And also in the Justice Department, there's a guy named Sam Alito. Gee, I wonder what happened to him. And then there are all these other folks who would become important conservative law professors, all coming out of the Reagan administration or the first Bush administration. And so what Reagan had done is he had sort of created an institution, a set of legal institutions, which gives birth to what we now call the conservative legal movement. So it was conscious. It was self-conscious. It was something people were trying to achieve.
We did the structural history of the Reagan Justice Department and of the Federalist Society. And is there a way to talk about how those come about either independently or together at the same time?
The Federalist Society begins in 1982 as a student organization. by conservative students, originally at Yale Law School, who were dissatisfied with the legal liberalism of the Warren and early Burger courts. But then what happens is conservative lawyers and conservative politicians realize that there is this ferment going on in American law schools, and so they decide to connect with these student organizations. And as these people graduate from law school, they go into the Reagan administration, they become lawyers. And so over time, this network is created, network of smart young conservative lawyers who go out and create a network that exists in the academy, in the bar, and on the bench, and also in government. So it's this four-sided network. And that becomes the conservative legal movement.
Maybe the most important thing to understand is that the birth of the conservative legal movement perfectly coincides with, and actually in many ways is the prerequisite for, originalism. Here, fun, President Ronald Reagan, speaking at the Federalist Society in Washington, D.C. in his very last year of office, celebrating all the wins that the conservatives had pulled off.
How far we've come these last 8 years, not only in transforming the operations of government, not only in transforming the departments and agencies and even the federal judiciary, but also in changing the terms of national debate. And nowhere is that change more evident than in the rise of the Federalist Society on the campuses of America's law schools. Today, you are vexing the dogmatists of the left. The Federalist Society is changing the culture of our nation's law schools. You are returning the values and concepts of law as our founders understood them to scholarly dialogue, and through that dialogue, to our legal institutions. Yes, you are insisting that the Constitution is not some elaborate inkblot test in which liberals can find prescribed policies that the people have rejected. You are fighting for renewed respect for the integrity of our Constitution, for its fundamental principles, and for its wisdom.
Sartre said hell is other people, but he never heard Ronald Reagan deliver a speech to a Federalist Society convention.
We're going to pause for a quick break. When we come back, originalism as theology for lost conservative lawyers. This episode is brought to you by NetSuite. Quick math. The less your business spends on operations, on multiple systems, on delivering your product or service, the more margin you have and the more money you keep. But with higher expenses on materials, employees, distribution, and borrowing, everything costs more. So, to reduce costs and headaches, smart businesses are graduating to NetSuite by Oracle. NetSuite is the #1 cloud financial system, bringing accounting, financial management, inventory, HR into one platform and one source of truth. With NetSuite, you reduce IT costs because NetSuite lives in the cloud with no hardware required, accessed from anywhere. You cut the cost of maintaining multiple systems because you've got one unified business management suite. You improve efficiency by bringing all your major business processes into one platform, slashing manual tasks and errors. Over 37,000 companies have already made the move, so do the math. See how you'll profit with NetSuite. By popular demand, NetSuite has extended its one-of-a-kind flexible financing program for a few more weeks. Head to netsuite.com/amicus, netsuite.com/amicus, netsuite.com/amicus. This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Choiceology is a show all about the psychology and economics behind our decisions. Each episode shares the latest research in behavioral science and dives into questions like, can we learn to make smarter decisions? Or what is the power of negative thinking? The show is hosted by Katie Milkman. She's an award-winning behavioral scientist, professor at the Wharton School, and author of the best-selling book, How to Change. In each episode, Katie talks to authors, athletes, Nobel laureates, and more about why we make irrational choices and how we can make better ones. Choiceology is out now. Listen and subscribe at schwab.com/podcast or find it wherever you listen.
So, originalism sounds so fundamental and eternal, like something that we must have been doing from the very, very beginning.
Yeah, it really does. And there are those, including Professor Jack Balkin, who argue that at different times, this mode of interpretation has been used by both progressives and by conservatives to try to get the outcomes they want. But this modern brand of originalism is definitely a child of the 1980s. And it's a child of the 1980s, but it's wearing a tricorn hat. And that may be part of the reason it's just so appealing. It has this aura of coming from the very beginning. It's an origin myth that maps so well onto the ways we think about religion in this country, which is something else I asked Jack Balkin about. I would love for you to talk for a few minutes about religion, because there's such a strong religious valence to so much of this. And I know you talk about the sort of Protestant constitutionalism of the United States, but it is definitely, you write this in the book, quote, "A distinctive feature of American constitutional culture is its quasi-religious veneration of its framers and founders, not necessarily as they were understood in the past or in their own time, but as they're understood in the present." And this turns into this kind of weird braided thing where we have this kind of quasi-religious, heroic, myth-making story we tell about the framers. We have a kind of quasi-religious, deep affinity for the Constitution as text, even as we fail to understand what's in it and what it means. And then into all that gets imported this kind of quasi-religious enterprise of, the sort of high priests telling us what the other high priests thought it all meant. And I would just love for you to, if you would just fulsomely tell me how this maps on to this very strange, fraught American religion of the Constitution.
Okay. So first, let's talk about the hero worship. Then let's talk about the relationship between religious culture and the Constitution. Hero worship, very simple. Compare America to Canada. Canada is produced through the British North America Act, and then later in 82 through the repatriation of the Constitution to Canada, and then the Charter. The Canadians have a constitution that protects rights and liberties and allows government to do stuff. They don't have the same kind of worshipful attitude toward the people who over many years create Canada. The French have a revolutionary culture. They had a French Revolution, but the French don't revere the revolutionaries as we do. That's because some of the revolutionaries are people like Danton and Robespierre, who are very complicated individuals. What's interesting about America is it's a revolution, it's a political revolution and a revolutionary culture, and it's a revolution in which the country, the imagined people, the American people, which that's a complicated question, and the nation all are supposed to have occurred at roughly the same time, and the people who make the Constitution are the people who make the nation, and who constitute the people as a people. This is a myth, by the way. This is not true. But that's the myth. It all happened at the same time. It's the Big Bang. And the people who did it are heroes because they made our nation and our Constitution, and we love them, right? So that's very American. And you won't find that combination, that magical combination, in a lot of other countries. It is true, however, of the American myth. And that's one reason why we venerate the founders. But we have a bunch of other culture heroes, too. Lincoln is a culture hero, right? Martin Luther King is a culture hero. Rosa Parks is a culture hero. So we have all these culture heroes in America who stand for great things and did wonderful things. But what's so interesting is that the original culture heroes are the founders as a group, and then there are individual ones, the big six, Washington, Hamilton, Madison, Jefferson, Adams, Franklin. These are the big six, and they stand out as special kinds of heroes. So that's America. That's just American culture. Now religion. So as you know, the American culture begins with radical Protestants coming to America. And then they all split up into different religious sects. But what they all have in common is a belief that you should really be serious about religious texts and the Bible. And you should read them carefully, and you should interpret them on your own, and you shouldn't be beholden to any special group of priests to tell you what it means. You should determine what Scripture means for yourself. This is also very American. It's how Americans think about their Constitution and their Declaration. People carry copies of the Constitution and the Declaration in their pockets. They pull them out and read them. You will not find people in other countries pulling out copies of their Constitution and reading them like it's Scripture. And that's the religious tradition in America. And it's, by the way, on the left and the right. It's not just about conservatives. It's liberals and conservatives. It's how Americans think about the texts that are constitutive of them. And the Declaration is treated often as important, if not more important, than the Constitution. Or as Lincoln says, it's the golden apple and the silver frame is the Constitution that surrounds it, right? And that's also very American. And this goes all the way through American history. It's not just the modern period. And that's a distinctive feature of our culture. Indeed, you can't understand American constitutionalism without understanding American culture. The two are basically joined.
And in a way, it kind of maps onto MAGA, claiming this return to a mythical past in the mists of time to facilitate these very radical outcomes today.
Yeah, Mark, as we're taping this, we're both looking at this image of the $59.99 in stock now due to high order volume. Please allow up to 4 to 6 weeks for delivery. Donald Trump Bible. God Bless the USA Bible, which Donald Trump is selling. And if you sort of look at the list of the things that are tagged onto it are pretty amazing. Bullet points include handwritten chorus to God Bless the USA by Lee Greenwood. Okay. The U.S. Constitution, the Bill of Rights, the Declaration of Independence, and the Pledge of Allegiance. So it is sewing together the sacred texts of the King James Bible to the sacred texts of the American founding documents.
Yeah, it's this fusion of Christianity and constitutionalism, right? We sometimes call it Christian nationalism, but I think it goes deeper than that here. This is such a vivid and grotesque illustration of the phenomenon where we treat actual sacred writ identically to how we treat Constitution written by largely white slaveholding men, all in a rush one summer trying to get something done and make a practical government that could actually work for the people. I mean, you know, to spend 5 minutes thinking about this is to realize that treating the Constitution like a sacred text is bad, wrong, and dangerous. And yet to let yourself be swept into the sheer vibes-based magic of the Constitution as an alt Bible, I mean, you can kind of see it, right? Think about how gratifying and how comforting it must be to believe that something like Article 1 of the Constitution is just as divinely inspired as the book of Exodus. I mean, this is a way to persuade yourself not only that America is immortal and based in divine truth, but that it will forever be thus, and that you, in interpreting the Constitution along conservative lines, are essentially a high priest of America's own founding texts, using them today to course correct back to where God wanted us all to be in the 1780s.
Right. And I guess we could think of Speaker of the House Mike Johnson as the zenith of this fusion, right? And as we're going to see as we go through this series, originalism in so doing, in saying that we have to always lean back into these immutable sacred texts and all their perfection, in so doing, they overturn hundreds of years of evolving, changing, growing, sensitive jurisprudence that morphs with the times for obvious reasons. And what they say is that this is the way it's always been done. And I just want to point out that we had a conversation with the brilliant Marianne Franks, and Mark, you and I are both super fans.
Absolutely.
About her book, The Cult of the Constitution, back in 2019, when she was really, I think, sounding out a clarion warning that this fusion of kind of cult-like religiosity and an evangelical sense that the Constitution is a holy document, not only that it was coming, but that it was going to come and kind of bring mayhem and cruelty and horror to all of us.
So there's the dovetailing with religion that makes originalism so enticing to the right and to their political base. And there's this real appetite on the right for something, some way to refute the Warren Court. And that's why some scholars date originalism not just back to the early 80s and the Reagan administration, but to Brown versus Board of Education, right? Because the Supreme Court rules in 1954 that segregating schools on the basis of race is unlawful. It's a frontal assault on Jim Crow. Republicans, conservatives, segregationists all rebel. They say this can't possibly be right. Now, Brown itself was an avowedly non-originalist decision. The court says, we reviewed the historical materials. It doesn't point clearly in one direction or the other. So opponents of Brown seize on that and say, well, the court has to follow history. They have to follow original intent of the framers. And we are certain that the framers of the 14th Amendment would not have wanted mandatory integration of schools between the races. And so for some scholars, and I think this is a plausible claim, that is the beginning of this revolution, when conservatives latch on to originalism as a way to undermine the signal victory, the chief victory of the Warren Court era. And that sort of methodology ends up getting laundered through conservative academia and through conservative politics to a point where it's now palatable in the 1980s for much more mainstream Republicans.
So there it is then. I think we've probably laid out why originalism is so very appealing. First, it maps onto America's ideas about itself and this kind of promise of Arcadian revival, a return to the source. And it gives conservatives a brand, and it gives conservatives an opportunity to disparage and sneer at the Warren Court. And also, it becomes a playbook for correcting what they've been campaigning against, which is so-called judicial activism, right? The claim that judges just make stuff up and they import their own values and their own ideas onto their constitutional interpretive methodology. And so this is a corrective for that, right? We're going to turn it into a science, and this is a science that is easily deployed, and it's going to constrain everybody. And so the promise that originalism comes with is that not just that we're all going to agree on this methodology, but that there is a sort of scientific certainty as to where this will lead us all. And so originalism comes to us cloaked as a theory of, believe it or not, perfect judicial restraint.
Yep, it's an ideal package, especially after the years of the Warren Court. You have a lot of the country convinced that issues like crime that are perceived as out of control and spiraling are all attributable to excesses of judicial activism on the Warren Court. Originalism comes along as the answer to that all we need to do is reimpose original meaning, and all of these problems will just poof, go away. And so then the question for the conservative legal movement as the 80s goes on, and by the end of the 1980s, is, okay, but can we actually use originalism to get what we want? It's a fun theory, but they haven't really been able to take it for a constitutional spin yet. And the first constitutional spin is going to be, of course, the Second Amendment.
We're going to take a quick break. When we come back, Justice Scalia enters the chat.
It's hard to imagine a world where we leave future generations with fewer rights and freedoms. The Supreme Court has stolen the constitutional right to control our bodies. Now politicians in nearly every state have introduced bills that would block people from getting the essential sexual and reproductive care they need, including abortion. Planned Parenthood believes everyone deserves access to care. It's a human right. We won't give up and we won't back down. Help ensure the next generation can decide their own futures. Donate to Planned Parenthood. Visit plannedparenthood.org/future.
This episode is brought to you by Shopify. Do you have a point of sale system you can trust, or is it a real POS? You need Shopify for retail. From accepting payments to managing inventory, Shopify POS has everything you need to sell in person. Go to shopify.com/system, all lowercase, to take your retail business to the next level today. That's shopify.com/system.
And the justice who is going to take originalism for its first constitutional spin is Antonin Scalia. He was confirmed in 1986, a year before Robert Bork was nominated. The Senate was very distracted with the confirmation hearings that were happening at the same time, elevating Justice Rehnquist to the Chief Justice's seat. And so Scalia sort of skates through, and he also does just a little bit of hide-the-ballism during his own confirmation hearings. Scalia is often thought of as the originalist, but truth is, it doesn't really come up as originalism qua originalism during his confirmation hearings. And the very first time Justice Scalia used the word originalist in a Supreme Court opinion, well, that's not until 1995 in a dissent.
So Scalia enters the chat, and we've reached the point where originalism is given its first big test for proof of concept. Can this theory, this methodology, can it be used to create new rights out of the whole cloth of original meaning? That first test will be guns, and the case will be Heller versus District of Columbia.
Okay, so Mark, could you just walk us back to the absolute fireball that is Heller, which really does disrupt an almost uninterrupted methodological, intellectual, political way of looking at the Second Amendment. And not only does it do that, but it convinces us all that this is the way it was supposed to be from the jump. Talk about Heller.
So Heller is the culmination of years of work in the conservative legal academy and conservative think tanks, Republican politicians trying to get a gun case before the Supreme Court. They've developed this theory that the Second Amendment protects an individual right to bear arms. They're trying to get a vehicle before the justices. Finally, they land on Heller, which is a challenge to a handgun restriction in the District of Columbia that makes it very, very difficult for individuals to buy and keep handguns in the home. They get a favorable decision in the lower court. That means basically there has to be an appeal to the Supreme Court. And so finally, after years of work, gun activists have their moment in the sun. They have teed up for the Supreme Court this monumental question: does the Second Amendment protect an individual right to keep and bear arms? Here's Saul Cornell. He's the Paul and Diane Gunther Chair in American History at Fordham University. He also teaches law as an adjunct at Fordham Law School, and he is an authority on early American constitutional history and law. And this is Saul describing to me how Scalia did the trick in Heller.
So Heller is a kind of magic trick by a not particularly mysterious magician, Antonin Scalia. And there are a couple of parts of the magic trick. One thing that Scalia says is that this is a pre-existing right. Now, the problem with that is, if you look at where he gets that from, it's from late 19th century judges around the time of a case called Cruikshank, which is, arguably one of the more horrifying decisions scaling back the 14th Amendment and Reconstruction. And for originalists like Scalia and many originalists, American constitutional history is like a single moment in time. If you need to go backwards, forwards, anywhere, and you pull something, you can apply it to the original meaning of the Constitution. What the Second Amendment jurisprudence, and Heller is a good example, is all history is created equal if it suits us, and any history that doesn't suit us is presumptively either irrelevant or there's not enough of it. So, I like to say that the Scalia law is you always need one more piece of evidence than you have to persuade me.
So he's doing this trick. He says it's a pre-existing right. How does he write out the very first part of the Second Amendment, which is all about the militia?
Right.
How exactly does he get to where the libertarians and conservatives in their law review articles bogus history is, and push past this idea of a well-regulated militia into this is so everyone can have handguns?
Right. So he does this by offering what is truly a Kafkaesque reading of the text, saying, okay, I'm going to set aside the first part and do the second part first. And then once I decide what the second part means, I'm going to go back and look at the first part and make sure I got it right. So essentially what Scalia says is, look, preambles don't state the purpose, they state a purpose. So once you say that, and if you look at the footnotes, he draws that from late 19th century or mid 19th century treatises, which the founders didn't have access to. You would think if you're an originalist, you would actually look at either case law from the period or treatises from the period. And if you look at those, what you realize is preambles are very important because they are the key to unlocking the meaning of the person who wrote the text. So Scalia, by saying, I'm going to use this 19th century rule for how you use preambles, is able to essentially erase it and turn the Constitution into an Etch-a-Sketch, and what's amazing, and I still, my head kind of can't really get around this. John Jay, a not insignificant figure from the founding era, first Supreme Court Chief Justice and co-authored the Federalist, decides a case from almost the same time of the Second Amendment, I believe it's Walker v. Jones, in which he says, well, a preamble doesn't change the meaning of the text. It can't expand it or narrow it. But where there are two possible readings, it is the tiebreaker. Scalia relied heavily on an article by Eugene Volokh from the Volokh Conspiracy that had been thoroughly trashed and discredited by historian David Koenig. And that had been included in the briefs, but he just chose not to pay attention to the critique.
He just ignored the rejoinder.
He would totally, and that's very typical of originalists. When you're trained as a scholar in history of political science, you can't just ignore stuff that doesn't agree with your argument. You really have to do a thorough canvassing of the scholarly literature and deal with it. But as a lawyer, there's no obligation to do that.
You can just ignore it.
Scalia ignores the critique of Volokh's work, which is devastating. And he reads the Second Amendment backwards. And Justice Stevens says, we've never done that. I mean, the Second Amendment is not written in Arabic, Hebrew, or Yiddish. You don't read from the other side of the page. But yet Scalia does this thing. And of course, the argument is totally circular because he basically says, well, why would you consult the preamble? That can make things more ambiguous. And actually, the other thing is the linguists had filed a brief saying, look, we have looked at all the uses of the phrase bear arms, and they're almost all some kind of military understanding. And Scalia says, I don't care. Who cares what a bunch of linguists think? I read some of the text and I say no. And Scalia erroneously says that the only time that bear arms has an exclusively military meaning is when it's bear arms against. But that's clearly not true because there are all kinds of examples of individuals able to bear arms, capable of bearing arms, those subject to bearing arms. And as I like to point out, a Quaker might carry a gun to kill, a fox eating his chickens or maybe to hunt a turkey, but they didn't bear arms. There's a difference. And then Scalia has this wild thing about the Quakers in Heller where he says, the reason the Quakers didn't bear arms is because so they wouldn't have to get into gunfights when they were in the military, which is just kind of daft because Quakers already had won the right not to, bear arms in the military. What Quakers didn't want to do was even to pay taxes or pay for substitutes to bear arms in their place. So his reading of all this is just nutty.
So he's just fully making stuff up at this point.
I mean, he's relying on out-of-date scholarship. He's making stuff up. He's just having a field day.
Mark, I'm a little struck listening to Saul Cornell standing there hopping around saying, the emperor has no clothes, the emperor has no clothes, as all of us just move on and berobe the emperor. Okay, so Heller answers the question of whether originalism, a theory, can deliver real-world outcomes at the highest court of the land. It can. It's pretty easy. Check. It's also the point where we somehow arrive at this mutual acceptance from the left and the right wings of the court that this is how we do it now. This is the project. This is how it's always been, and this is how we will all play the game. And that part of it is what we call the trap. With Heller, we can see that originalism starts to eat the law. Because going back to the original text and meaning takes us back to a time when women were chattel and enslaved people were property. To state the very obvious, that's not how modern, inclusive, egalitarian democracy is protected and fostered. But it's not just the premise that's the problem, if only. In its actual practice, originalism and its search for history also picks and chooses, defines and then redefines what counts as historical evidence. Originalists do their own research, reaching for selective texts and ancient dictionaries. In Heller, Scalia says he's doing history, but he's actively ignoring historians who disagree with him. And like I said, I don't think we fully clocked what was happening at the time when Heller came down. So on our next show, join us as we zoom in on originalism's effects once it reaches beyond the Second Amendment and into other areas of the law, like voting rights. We're going to find out what happens when progressives try to beat the originalists at their own game. And we'll find out from a judge how originalism is affecting the job of, well, judging. Next week on Amicus, we're tackling the trap that is originalism.
When precedent is for suckers, and we don't know whether settled law will become unsettled every June, it's really hard for the judiciary to function.
There's something that I now affectionately call the vast originalism industrial complex.
Yeah, it's not about the reasoning. It's not about law. It's about power. It's about oppression and subordination and who gets to really count as an American.
Slate Plus members, you can listen to this week's bonus episode right now, an extended interview with Professor Jack Balkin on the history of originalism and about his book, Memory and Authority, The Uses of History in Constitutional Interpretation. If you are not a Slate Plus member, you can listen to that episode now by joining Slate Plus. Not only will you unlock exclusive bonus episodes of Amicus, but you'll also access ad-free listening across all of your favorite Slate podcasts. Subscribe now on Apple Podcasts by clicking Try Free at the top of our show page, or visit slate.com/Amicus Plus to get access wherever you listen. And that is a wrap for this episode of Amicus. Thank you so much for listening in, and thank you so much for your letters and your questions. You can keep in touch at amicus@slate.com. Time is really running out to get your tickets for our live show in Washington, D.C. on May 14th. Go to slate.com/Amicus Live to snag some tickets and get more details, and we will pop a link in the show notes. Slate Plus members, not only can you get a discount to the event, which you can find on your account page, but also a selection of our live event will be reserved exclusively for your questions to our expert panel. You can submit those questions with the subject line originalism to amicus@slate.com. Sarah Birmingham is Amicus's senior producer with help from Patrick Fort. This episode was mixed by Slate's Senior Technical Director, Merritt Jacobs. Alicia Montgomery is Vice President of Audio at Slate. Susan Matthews is Slate's Executive Editor. And Ben Richmond is our Senior Director of Operations. We'll be back with another episode of Amicus next week. Until then, Hang on in there.
For the ones who work hard to ensure their crew can always go the extra mile, and the ones who get in early so everyone can go home on time, there's Grainger, offering professional-grade supplies backed by product experts so you can quickly and easily find what you need. Plus, you can count on access to a committed team ready to go the extra mile for you. Call, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
Hi, this is Dahlia Lithwick, host of Slate's legal podcast, Amicus. If you're listening to this show, you might be interested in Amicus's live show that we're hosting in Washington, D.C. on Tuesday, May the 14th. My colleague, Mark Joseph Stern, and I will be talking to some amazing guests, including Sherilyn Ifill and a sitting state Supreme Court justice, all about how originalism, a relatively recently invented way of interpreting the Constitution, has taken over the Supreme Court and radically reshaped the law. It's been doctrinal rocket fuel for the conservative legal movement and facilitated the rolling back of abortion rights, the expansion of gun rights, and the obliteration of the separation of church and state. And as another wildly consequential Supreme Court term careers to its end, the court's originalists are on a tear. But there's something you can do about it, and we hope you'll join us in D.C. on May 14th to explore the possible pathways out of the current situation. Go to slate.com/amicuslive for tickets.